That's not. But there's three broad issues. Number one, the real issue in a marriage which is broken is maintenance and custody. That's the real issue.
Yes.
Divorce is used, not giving divorce, is used as an instrument to ensure I get the best order on custody and the best order on maintenance. What this court needs to do is to divorce these two issues. These are two separate issues. The core issue in a marriage, if it is not working, is maintenance and custody.
No, there is another issue also in the Indian context. I have dealt with up to number of cases where sometimes I told you the women have gone as far as to say, yes, he is married another, he has a child, then both women have equal status, but don't take away my status.
No, I'm coming to that. That's a separate issue. What I'm saying is, Malad, in India, marriage at the inception is a social contract. Once the marriage has taken place, then it becomes a matter of choice. Now, that social contract, as my learned colleague said, involves family, it involves caste.
Many factors.
Many factors. So when you enter into that marriage, Malad, it's part of that social contract. Now, after 3 years, 4 years, 5 years, you feel I can't live. Now, that's personal autonomy. That's choice. That's can't be wasting my life from 40 to 55. The petition for divorce. Losing my life in the process.
You were not there when Mr. Indra Jaising was there.
I'm just saying.
She said you had a choice, you could have done this when you were the law minister.
So, Manoj, therefore, the point that I'm making is there is an issue of personal autonomy and there's an issue of social contract. And therefore, that power should not be given to the trial court, that power should be exercised by you. Now, the question is, how do you exercise that power? What's the procedure? Well, I dare say, to prove cruelty is almost impossible. To prove adultery is almost impossible. Well,
Many cases succeed.
No, but in the context, of course cases succeed, but in the context, it's very, very difficult. It carries on for years. Therefore, so by the time you come to this court, the marriage is over. And then you will consider it, and the most precious.
What is the solution?
I'm coming
to the level. Because we know that all these cases are wrong. So one of the argument was, when you were not there, that if you are saying there is an irretrievable breakdown of marriage, there has to be fact finding.
Correct. I was coming. I knew, Manoj. I was coming to that. I had three more minutes, Manoj. I'll come to that. Now, Manoj, when you divorce when you segregate divorce from maintenance and custody, then you can file affidavits. Now you come to the procedure before the trial court, the family court, saying this is what has happened, this is how he is adulterous, or this is how he is dealt with me. That response in affidavit will come, and the trial judge can come, family court can come to the conclusion that prima facie, this seems, and the test has to be much lower than the test that is applied normally. Much lower. And if prima facie comes to that conclusion, that matter, the family court can't grant divorce, but it can come to that prima facie finding. That will shorten the entire process of litigation. You can come then to the High Court and come in 142 for you to grant the divorce. So please appreciate that the process is as important as anything else. If the process gets prolonged, 21 is effective. Whereas I have a case, and I've done several of them, where there is adultery. We know there is adultery. The father says, have a DNA test. Or the wife says, have a DNA test. He says, I won't have a DNA test. So then what happens? You can prove it. You know it. Where do you go? What do you do?
So Indra Jaising was saying that there has to be a structure for which he, of course, said that legislature somehow didn't take the call, which is irretrievable breakdown of marriage coupled with sharing of we call it wealth or means between the two parties who are married. If that financial aspect is taken care of,
yes,
he says the And that's, she gave examples of such kind of provision elsewhere in the world, where it is always structured with a financial. So
Malas,
she said even when it didn't pass the muster in parliament, it was because it was not coupled with a financial structure.
I beg to differ. I tell your lordship why. I beg to differ. Why? Because if you bring in the financials with a divorce, there will never be a settlement. One party will always want. You need to say, see, maintenance has to be granted. What happens in normal courts is interim maintenance, interim custody. We'll decide the matter at the final stage and then we'll grant
It
custody.
also comes to the Supreme Court.
That also comes to Supreme Court. In the meantime, people have lost their lives. So you need to evolve a procedure. A procedure, which is not inconsistent with the law. That's what you need to do.
You can do much better if where you are there, some lead is taken to bring in analyze law. Is it not? I'm not talking lightly. I'm actually saying that, if a parliamentary subcommittee would debate it out, bring a law into force,
Won't happen.
it will take care of so many things.
It won't happen. Honestly, tell you, it won't happen. There are too many cross currents in society for that to happen so easily. But that's why you need to evolve a procedure consistent with Article 21 in the context of what should happen in a family court without giving that power to the family court to come to a conclusion that this marriage actually is no longer viable. Forget about breaking down. It's not a viable proposition. And you cannot allow individuals to lose their lives litigating. And remember, mothers, the child is perhaps more important than the parents. Because the children are, the quicker divorce takes place, the quicker the children will settle. The longer the litigation, the longer for the children, it will be traumatic. So you need to evolve a procedure within the family court system, dehorse maintenance and custody, because that's the key issue. That can carry on, but on a summary, like you do nowadays, in commercial.
Mr. Sibbal, you are on this. You are completely at variance with what emergency can argue because of the reason you just now said. You talked about diverse thought processes and diverse situations in the society. In many cases, the divorce is gets stuck up. You're right because of maintenance, but right to fair maintenance is equally important.
I agree. I agree. Precisely the point I'm making, Manoj. That maintenance with resolution will never take place if you integrally link the divorce with the maintenance.
And they are intrinsically linked.
I am not saying no, mother. Please appreciate. I am not saying no. But if you want, mother, see, there is a right for the woman and the man to live separately. Mother, the 1976 judgment of an English court, the judge looking, the woman was in the witness box. The judge says she's a very charming lady, wonderful lady. I don't know why you can't live with her. He said, but don't look at it through your eyes. My eyes.
I can't even relate what one litigant said to the judge.
So the point is, mother, what may seem, correct, what may seem not cruel to the judge, what may seem not cruel to the judge may seem cruel to the individual. Well, it's all completely subject.
There is in an interpersonal relationship, there is always be a personal likes, dislikes. There is two very good human beings may not be good partners.
That's why
they can live together perfectly fine, but when they get married, there's something.
So therefore, a lower threshold. That's precisely the point I'm making. Lower threshold of proof. Lower threshold of proof, means not a viable marriage. And that's enough to fit in with the statute. Now, because it's impossible to prove these things. And forget impossibility. The nature of litigation is such that it takes years by the time the man or the woman have lost their lives.
The unfortunate part of all litigation now.
I'm sorry?
That's the unfortunate
No,
part.
but here it is personal liberty and personal autonomy. There's the difference for this. There's the Article 21 report. Because, the best years of my life, I think, 35 to 50. If you're litigating between 35 to 50 and you don't have a divorce, the end of the matter. or you lived for. You can't get it again. So you need, Millers, in the context of 21, you need to evolve a
The
procedure.
Dave is not agreeing, I'm not agreeing that that's the only best part of your life. I look, post-retirement is the best part of my life.
Alright. But I'm chiefly obliged, Millers. I'm just going to make some.
Yes.
With
Just
Diwali.
2 minutes.
2 minutes to you, and after that, the remaining 35, 37 minutes are for Mr. Dave.
Thank you.